which is the absence of the defendant from the court since 25th of April 2017 until he was produced on the 29th of June, my lord, which was exactly what the Supreme Court did. They said that he did not jump bail. These criminals came to my house to kill me. That's what the Supreme Court said. This is in your own ruling, in your own court, my lord. So I cannot understand, my lord, why my trial will be conducted contrary to the Constitution of Nigeria that said I must have free and unfettered access to my counsel. It's here. This is the law of Nigeria, my lord. And again, my lord, please, if you will permit me, my lord, this is the laws of this country, the extant law of Nigeria as of today. What does this Terrorism Prohibition and Prevention Act says I cannot be tried in Nigeria? That's the law of Nigeria. I can never be tried in any court of law in Nigeria. That's what the law says. Anybody standing in trial or coming to try me is a terrorist. That's what their law says. Not me. As simple as that. Section 2, subsection 3F of Terrorism Prevention and Prohibition Act. That's what it says. Any court considered to try me is committed an act of terrorism. Yes. Very clear. You cannot violate a treaty that Nigeria entered into and then come to try that very person is not done anywhere in the world. So you must be aware of that. So that is why there is all these ridiculous delays. That is what Supreme Court said. I did not jump bail. My home was invaded. They came to kill me and I survived. They came to Kenya to kidnap me, brought me back to this country and seeking to try me, which the law says cannot happen. You cannot violate a treaty that Nigeria entered into and then hope to stand on that illegality to conduct a trial is not done anywhere in the world. I have it in my case. Nobody has, there's no exception. No exception whatsoever. That's what the law says. Section 12 of the Constitution, what does it say? Any treaty ratified by Nigeria becomes law. It's law. You cannot change it. It doesn't matter what they do. All these shenanigans is just pure rubbish. You never stand. Not with me. I believe in justice and fairness. That's all.
Nigeria is signed to extradite, not to rendition.
Now you be terrorist. Nnamdi Kanu para for government lawyer as DSS and government don't decide and vow to keep Nnamdi Kanu under detention till further notice and to the end of his trial under this case of terrorism. Hey, my people, this one no be small matter again. Oh, I wonder wetin the people for the eastern part of the country, Nigeria, go they try to do like this, because anytime the government they suppress this man will be their voice. The people of the eastern part of Nigeria, now then they suffer, and because very soon now they go declare no movement and plenty things go happen because of say the federal government and DSS don't vow say they no go release them till anything wey go be the final case of the matter. Say in go dey for DSS office and in go dey wear only one clothes wey we use know am for long. Hey, today full details, make we roll am.
Hey, wait, don't play that video yet. Welcome to Lost TV. This is your home of all daily Nigerian trending entertainment news and gossip you need to see and watch. Yes, we keep you entertained 247. Yes, 247. So just subscribe and press the bell icon to be notified anytime we drop the latest we do concerning your news and trending gist. So roll the video now. Roll it.
Leader of the secessionist indigenous people of Biafra, IPOB, Nnamdi Kanu para as him stand up to address the court. Kanu begin para as he talk straight to the judge. He begin accuse government lawyer Awomolo say him they go against the provisions of the Terrorism Prevention Act. You be terrorist. You no get any power to try me. The law talk am for section 23F of the Terrorism Prevention Act say nobody try anybody against the provisions of the law or against any treaty where Nigeria be signatory to. That person na terrorist. So now you be terrorist. I don't dey for detention now for 3 years for waiting. Kanu tell Awomolo. This they come after Justice Nyako of the Federal High Court Abuja reject the application to transfer Nnamdi Kanu to house arrest. Justice Nyako talk say she don't rule on the same application several times and she no go change her ruling. The ruling say yes, DSS custody remain the safest place where the accused person go dey. Any attempt to fight this application again, I go find them as abuse of court process. The only option open to the defense now to take the matter on appeal, Nyako talk. Also, on the issue of whether Kanu jump bail, Nyako tok say she bin don also rule say Kanu jump bail. The court say she bin don order say Kanu sureties go forfeit the bail bond wey dem bin agree. The only reason wey make dem never forfeit the bail bond na because dem appeal the decision. So bringing dis application before me again no dey necessary. If e happen again, I go hold am as abuse of court process, she tok. However, Justice Nyako order say Kanu lawyers go fit dey visit dia client for DSS custody 3 times a week instead of 2 times. She also order the DSS to provide Kanu a clean room where im and im lawyers go hold consultation without any monitoring or recording. After the ruling, counsel to the federal government Adegboyega Awomolo SAN tell court say dem dey ready to call dia first witness, but Aloy Ejimako wey be counsel to Kanu ask the court to grant dem adjournment so dem go take advantage of the latest ruling to prepare dia client for trial. Ejimako try to insist say the condition of detention dey very oppressive for Kanu, but Justice Nyako tell am to go on appeal. The matter between Nnamdi Kanu, leader of the secessionist Indigenous People of Biafra (IPOB), and the federal government continue on Monday for the Federal High Court, Abuja. The case wey start around 12 o'clock Nigerian time dey before Justice Nyako, wey don dey in charge of the matter since government first arraign Kanu in 2015. Kanu dey face 8-count charge wey border on terrorism and belonging to a proscribed organisation because of im fight make the southeastern part of Nigeria pull away to become dia own country wey im name go be Biafra. E dey important to note say since the Nigerian government rearrest Kanu for Kenya in June 2021, im trial never actually resume sake of the many complaints wey im lawyers dey make against the Department of State Services (DSS), wia Kanu currently dey detained. Aloy Ejimako, wey dey usually tok on behalf of Kanu, dey allege say im client never dey ready for trial because of DSS no dey allow am and im other lawyers to get unhindered access. For the latest hearing dey in April, Ejimako bin tell Justice Nyako say dia visit for the DSS cell na for just 30 minutes per counsel, and the DSS pipo no dey gree for 2 lawyers to see him at a time. Dem no dey fit enter with any writing materials to take notes, and dia conversations dey monitored all the time. We dey apply make our client dey transferred to home detention or house arrest. Ejimako bin beg the court dat day. The defence counsel make dis plea after Justice Nyako bin don refuse several times to transfer Kanu from DSS custody to Kuje Correctional Facility, as she tok say she no get confidence in the security of the facility. E dey expected say Justice Nyako go rule on the application on whether to grant Kanu the house arrest wey im apply for. Also, the federal government dey expected to call dia first witness wey go signify say trial don actually begin. Justice Nyako bin threa ten say if Kanu and im team never dey ready for trial, she no go get any other choice than to adjourn the case since until wen dem don ready. Omo, hey, wahala. So right now, if you no understand the whole thing wey I dey talk, wetin I dey try to talk say, as all these things dey happen since 2021, dis thing na the 3 years wey dey don arrest dis Nnamdi Kanu of Biafran pipo, dia leader. Since dat time, dey never even start the trial for why dey arrest am. Im lawyers are still arguing and fighting over the treatment of Department of State Services, that is DSS, on dia cell terms for Nnamdi Kanu as im dey dia prison. Say the DSS no dey allow make 2 lawyers or 3 lawyers come the same time come see Nnamdi Kanu for inside prison, say na one after the other, and na 30 minutes, and on top the 30 minutes, say dem still no allow dem carry writing materials nor phone, say na just mouth to mouth talk. Na when you come out you go start to dey write wetin una talk, and na only you and him per person. Say na wetin dem dey fight since o, They don't fight for change of clothes, fight for change of clothes, fight for change of clothes. DSS no gree change in clothes. Now they don dey fight for time allowance. DSS no gree, but this particular court, the only good about it for Nnamdi Kanu is that he has been allowed to see his lawyers 3 times in a week instead of 2 times. And then Justice Nyako don order DSS make dem fit allow more than 2 lawyers to come see am at the same time. So maybe with this new update and with this new this thing process wey don sup now, e fit sure say they go dey ready say next time wey they go see the trial go begin, because federal government they are ready with their first witness already in the court. That is it for now. So like this now, the people of the southeastern part of Nigeria, that's the Igbo tribe and some other tribes in there, should be ready for major problem in that area, because their soldiers, the Biafran soldiers and army, will not take it lightly with the treatment from DSS. That is it, my people. Don't forget to subscribe and click the bell icon to be notified anytime we drop more story on here. I would like to hear from you what you have to say on the comment section about this issue. Thank you. Namaste. Bye-bye.
Thank you. I go by the name Black Mamba. Don't forget, I thank God for my subscribers, my phone, and my sub. If you like, if you comment, if you subscribe, I'll keep thanking God for you. I love you all.